Thank you, Eddie. And thank you, Delhi and everybody. On behalf of the Bees African International Studies Working Group, the Dundee Africa Research Network, and the Department of Politics and International Relations at the University of Dundee, I would like to welcome you to today's discussion with the Right Honourable Professor Mujib Alabi. Professor Mujib Alabi is Professor of Political Science and Professor of Public and International Law at Osun State University in Nigeria. He is a member of the Nigerian Bar and served in the Nigerian House of Representatives from 2015 to 2019. During this period, he served as Deputy Chairman of the House Committee on Human Rights, was Chair of the Nigeria-UK Parliamentary Friendship Group, and served on numerous committees. He was also Speaker of the Osun State House of Assembly from 1999 to 2003. He is an expert on good governance, has authored numerous publications on government institutions, leadership, and policy analysis, and has served as a consultant for numerous governmental and non-governmental bodies. The title of his talk is Human Rights and Regional Integration in West Africa, a discourse on the ECOWAS Community Court. Professor Alabi's talk will be followed by comments from Dr. Peter Brett. Dr. Brett is a senior lecturer in international politics at Queen Mary University of London. He has written 2 books on the politics of international law and international courts in Africa. His most recent, which was co-authored with Line Ngbo Gisel, included a chapter analyzing resistance to the ECOWAS Court. And I'm going to turn it over to Professor Alabi for his comments. Professor.
Prof, sir, you need to...
Yeah, I think you're muted.
Hello, are you hearing me?
Yes.
Hello. Is anyone hearing me? Thank you, the organizers of this talk shop, for the opportunity given to me to share my thoughts on the development of one of the modern agencies of international development, particularly here in Africa, the Court of Justice of the Economic Community of West African States. Let me seize the opportunity to thank the Dundee Africa Research Network for giving me the opportunity, and to thank the chair as well as other members of the panel for sparing the time to come and participate in this particular talk show. I will be talking on the human rights and regional integration in West Africa, a discourse on the Community Court of Justice of the Economic Community of West African States, which I will continue to refer to here as the ECOWAS Court. I know many of us, when we Google the ECOWAS Court, you're likely going to be seeing a number of things concerning recent decisions taken by the court in the promotion of human rights across the region of West Africa. But one thing is that this particular court, which we call the Community Court of Justice of the ECOWAS, was not set up as a human rights court. For those of you who are used to Europe, you'll be thinking of the court in Strasbourg. The ECOWAS court did not have that kind of mandate originally when it was set up. It became a body in the forefront of human rights protection as a result of necessity, because originally the ECOWAS itself was a kind of an attempt at a common market for the promotion of socio-economic development across the continent of West Africa. And when it was originally started, there was no provision for a court. Rather, what they had was an arbitral tribunal that will resolve minor disputes among members of the quote-unquote common market. So, but unfortunately, when the ECOWAS Court was set up in 1991, precisely in July of that particular year, the 16 member countries of the common market signed the protocol for the establishment of the court. It took them almost 10 years before the protocol could be ratified. And even when it was finally ratified and the court was inaugurated sometimes in January 2001, the court did not have much to do. And for the first 4 years of its existence, there was only one case that came to the court for determination. And therefore, by 2005, because the court was not witnessing the kind of robust engagement expected of the founding father of ECOWAS, the protocol establishing the court had to be revised, and a new supplementary protocol on the court was adopted. There were two major characteristics of the supplementary protocol. In the first instance, the supplementary protocol widened access to the court. Initially, only member states of the ECOWAS, only institutions of the community were allowed to institute cases before the court. And as I told you, within a space of 4 years, only one of such cases was instituted. Even the only one that was instituted was by a community citizen. And the case was easily determined by the fact that as of that time, October 2004, there was no provision that allowed individual citizens of the economic community of West African states to bring cases before the court. So it was easy for the court to dismiss the case. And so the 2005 supplementary protocol had the advantage of allowing individuals, including non-governmental corporate bodies, to file cases before the court. Secondly, the supplementary protocol of 2005 also expanded the jurisdiction of the court to cover, more importantly, the issue of human rights violations. For those of us who are used to West Africa and even Africa as a whole, you will know that the human rights records of most of the countries of this continent are not something that we can say is enjoined about. But until then, such issues could only be raised within the national judicial framework of each of the 16 member ECOWAS countries. And even though the African Charter on Human and People's Rights had been adopted in Africa since 1981, there has not been any major improvement in the human rights record of the continent, of the countries of the continent as of that time. So in 2005, the year 2005 was a major turning point in the history of the course of justice of ECOWAS, because there was a widened access to the framework of the court that allowed individual and non-governmental bodies to bring cases before the court. And secondly, issues of human rights, which was hitherto not part of the jurisdiction of the court, was added to it. And with this, the court began to witness a transformation in terms of the number of cases that were filed before the court during the period. It witnessed a transformation in terms of number of sessions that were held by the judges of the court. It also marked a transformation in terms of the number of judgments that were given by the court. So in this particular figure, you most likely is going to see how the docket of the ECOWAS court had increased within the first 5 years. And I'm trying to see if I could share my screen so that you see the astronomical rise. The astronomical rise in cases filed before the court consequent upon the adoption of the supplementary protocol in 2005. Are you seeing the screen being shared, please?
No, we are not.
I'm trying to share the screen. I've clicked on share the screen.
I think Eddie needs to permit.
Okay, can you see it now?
Yeah, there you go.
Okay, it's about
It's coming. Yes.
Okay, yes, sir.
You can see the court was inaugurated in January 2001. There was even no case. You can see how it was rising. The supplementary protocol was brought about in 2005, and you can see the astronomical rise in the number of cases filed from about 2006 going down to 2007, 8, 9, and again 2011. And today, in another figure which I'm going to be sharing later, you see that today the court is very, very busy in terms of making pronouncement on matters pertaining to human rights and other aspects of the work of the ECOWAS as an economic community. Then the issue that challenges us, which is perhaps what we are trying to focus on in this paper, is to what extent has the astronomical rise in the human rights jurisdiction of the court affected its role, the role of the court as a regional integration court. If you Google the ECOWAS Court of Justice today, you're likely going to be seeing the monumental judgment and decisions that the court has made in promoting human rights in West Africa. The question is, the court was not set up as a human rights court. The question is, having now doubled at human rights matters and becoming so notable in that area, has that got any effect on the import of setting up the court in the first instance, which is to promote regional integration? Of course, I did a review of the work of our colleague scholars. Some of them believe that the addition of human rights jurisdiction to the work of the court actually served to promote regional integration, while some believe that in going into human rights litigation, the court is virtually forgetting about its initial role, as a regional integration court set up particularly to promote regional integration in West Africa. So when you look at the human rights jurisdiction of the jurisdiction of the court, you will see that we can be classified into two broad areas. I said, in the first instance are those group of cases which are tangential and crucial to the core objective of regional integration, but they constitute the greater proportion of the cases that have been coming to the court since 2005. Those are cases that border on allegations of human rights. On the other hand, are the second category of cases that pertain essentially to issues that border on the promotion of the core objectives of establishing a regional economic community. This is the area that corresponds to the jurisdiction of the court, and they include actions for enforcement of treaty obligation against member states for infringement or non-fulfillment of obligations under the community treaty. Action for control or review of act of the community, its institution, its official, to determine their legality or otherwise. And lastly, action that deals with relationship between the ECOWAS court on the one hand and the national court of the member state on the other. So we'll go ahead to now look at the performance of the court in these two broad areas. And we are starting with the role of the court as a court for the development of the regional legal order in West Africa. I titled that one, Regional Integration Jurisdiction. I said the ECOWAS court was established first and foremost as a regional integration court. And the addition of human rights jurisdiction was later to enable it to play a more assertive role in human rights situation in the West African sub-region. And since then, you will discover that the jurisdiction of the cases that are coming before the court, other than human rights cases, are less than 10%. Are less than 10% of the cases that come before the court. Even of these 10%, some of them have to add human rights violation as subclaims for them to be able to succeed. So in a number of cases, since about 15 years to this time, the ECOWAS court has laid down certain guiding principles which individuals and corporate bodies must meet before they can activate the regional integration jurisdiction of the court. I gave a number of these cases which we need not go into one by one. But what the court has emphasized is that for anybody, any ECOWAS citizen, individuals or non-governmental bodies to come and challenge the actions or inactions of the community or of the community institutions or of the officials of the community, they must demonstrate that they have suffered certain depravity that will entitle the court to find in favor of them. Thus, in a case, a very popular case of Salida and the Council of Ministers, where a particular official of the community challenged a regulation that reserved a particular position for member state of the ECOWAS from a particular country as discriminatory against him as a community citizen, the court did not find him, the case did not succeed. Because according to the court, this particular individual has not suffered anything in his person sufficient enough for him to bring the case. Apart from that, in another case where an employee, everybody is challenging, you must show sufficient interest as an employee, if it's an employee-employer relationship, not as a prospective employee or not even an outsider. So this requirement of sufficient standing, which lawyers will call Lukun standing, has been a major factor that has deprived community citizens from bringing up cases to deepen the regional integration process before the court. And therefore, even when the ECOWAS court unlawfully terminates the appointment of a staff, the only thing the court could do was to award monetary damages rather than reinstating the staff back to his position. The ECOWAS court said it could not do that. We have had several cases, including cases, the case of Femi Falana, who challenged some countries of the ECOWAS for putting on barricades at the national boundaries of each of these states as a violation of the protocol on free movement within the ECOWAS sub-region. The court found that to the extent that such barricades, such boundaries between one country and the other has affected the litigants in countries where he visited at that time, they could award damages. But in those countries where he did not visit, the case was merely speculative, and therefore it was dismissed. This list of limitations put in the way of bringing about regional integration court has deprived community citizens of the opportunity of coming before the court to emphasize the need to promote those things that will enhance the regional integration effort in the community. Let us look at the other aspect of the jurisdiction, which is the human rights jurisdiction, which is the one for which the court is very well known nowadays. And like we have said before, this is indeed one area that has improved the docket of the court to the extent that today the ECOWAS court has been described as a court that is becoming increasingly active and a bold adjudicator of human rights in Africa. And the court has taken a number of vital and important decisions that have served to deepen the cause of human rights in Africa. The court has in Hadijatu, Mane, Kurua, and Niger tended to protect a community citizens from being taken as slaves. The court has helped to deepen the community citizens in terms of protecting socio-economic rights that are not even recognized by the national courts of the member state. The court has given judgment against inhuman treatment and discrimination. The court has even given judgment against Nigeria as the big brother in Africa here against environmental degradation. These are important matters which the court have considered grave violations of human dignity, disregard for the due process of law, and extension of retroactive provision of legislation in criminal cases. Some of these cases are cited, and today the Economic Community of West African States Court of Justice has become a leading adjudicator of human rights litigation across the sub-region of West Africa. But even then, the court is challenged by a number of problems and limitations, which has slowed down the extent to which its contributions could be considered meaningful. We need to remind ourselves that the ECOWAS Court of Justice was set up originally to function in fashion that is probably similar to the Court of Justice of the European Union. But you can definitely not compare the two. Apart from the fact that the contextual environment in which the two courts germinate are different. Don't forget, originally, the founding fathers of ECOWAS did not deem it fit to have a court of justice. What they provided for was a mere arbitral tribunal, probably because they did not emphasize that issues of regional integration could bring up contentious issues. Even when in 1991, the country decided to set up a court of justice, it took them 10 years to get the needed ratification. And even then, after the ratification, because of the gross deficiencies in the treaty, in the protocol establishing the court could not play a very meaningful role until about 50 years after it was originally set up. So in that sense, the political will for a strong regional court in West Africa is lacking. And apart from that, the court also suffers from weak legal, institutional, and environmental factors, notwithstanding that it is playing an increasingly visible role in West Africa in the last 15 years. This inadequate legal instrument and implementation challenges had made it very difficult for the ECOWAS court to function in a manner that we can begin to have a comparison between it and, for example, the CJEU, because it does not have the kind of legal backing that the CJEU is having, and the contextual environment within which it operates, it definitely is not as favorable as we found in Europe, where the Court of Justice operates. Unlike in Europe also, where you have the Human Rights Court, where you have the Court of Justice, where you have the Common Market Court, and the ECOWAS Court is a single court combining the functions performed by 3 different courts in the European context. And therefore, but nonetheless, within the African context, we can see that the ECOWAS Court has performed to some extent in ensuring that we have a measure of human rights and regional integration improvement in the continent. More importantly, however, is the enforcement of the judgment of the court. This has been a major inhibiting factor. By the protocol, the judgment of the court are final, and member states of the ECOWAS are expected to put in place the necessary framework to ensure the execution of the judgment of the court. As of now, not all the 16 member states have put on such framework. And even where such framework exists, there have been instances of judgment not implemented. When the ECOWAS court gave a judgment for the Nigerian government to condemn the environmental degradation in the Niger Delta area of Nigeria, the problem continues and is still persisting up to today. Nothing has been done and nothing is happening. In Niger, when the government awarded judgment against a citizen that was enslaved, up to today, the compensation has not been paid and nothing has happened. In essence, while the community legal text enjoin member states of the ECOWAS to ensure enforceability of the judgment of the court, there is no provision for default. There is no provision, for example, as we have in the EU, where the EU Commission could sanction a member state if it acts in default of the judgment of the court. In West Africa, we just left everything to the goodwill of the political leader. We left everything to the conscience of the political leader. But some have argued that even where such judgments are not enforced, the fact that the Court of Justice has come out boldly in support of those framework, in support of human rights promotion, in support of regional integration, presupposes that the court is playing a role unlike what we have before, when, whether in terms of implementation, whether in terms of condemnation. Hello? Hello?
We can hear you.
Okay. Whether in terms of enforcement, the court is still serving as, quote unquote, a community arbiter. Although its judgments are said to be compulsory, member states that go in default of just judgment have not been sanctioned. And to that extent, that constitutes a major challenge. So I concluded that section by saying, in the face of these myriad of challenges, the legitimacy of the human rights jurisdiction of the ECOWAS Court has been challenged, while issues remain around the extent to which the court can, in reality, hold the member state of the ECOWAS accountable for human rights violation. These are my conclusions. I say, while the establishment of the community court has been described as one of the greatest achievements of the ECOWAS, this has not propelled the community institution to the forefront in deepening the regional integration process in West Africa. Because notwithstanding the existence of the court, the various stages of the economic community has not been met, because members of the ECOWAS violate the rules with impunity. Nigeria has closed its border for more than 2 years now, and nobody is doing anything, notwithstanding that it signed a protocol on free movement. Some of us, like myself, I was born in Cote d'Ivoire, though in Nigeria. When you go there, you still see elements that does not suggest that they have a free right of residence, which the ECOWAS protocol provides. But nonetheless, the court is not established and cannot be described as a human rights court simpliciter. Notwithstanding the absence of human rights instruments specific to West Africa, the court has called in 8 available national, continental, and global instruments to play a more assertive role in holding member states of the ECOWAS accountable for violation of human rights. This is invaluable. This is appreciated. But the same cannot be said in respect of the vast area of an emerging community legal order, which is expected to facilitate regional integration as a vision by the original founders of the ECOWAS. While the court is deepening its powers in human rights litigation, it is seriously failing in its original goal of promoting regional integration. So I continue, I said, whether the deepening role of the court in human rights litigation has served a positive role for the integrative effort of the ECOWAS is doubtful. While some of our colleagues, scholars, do not see any contradiction in the role of the court in regional integration and in the protection of human rights, insisting that, and I'm quoting, the fundamental motivation for economic integration regime like ECOWAS is not at odds with the human rights principle, end quote. For me, and for those who believe in my line of thought, while strengthening human rights jurisdiction is necessary for attainment of the overall objective of development, which is the integration of West Africa, the ECOWAS court should be strengthened enough to play a more assertive role in facilitating supranational enforcement of national obligations and commitment, which currently seem to be lacking in the absence of a strong political will across the length and breadth of West Africa. For us, the human rights dimension of the court is appreciated, but nonetheless, the court still needs to do more. And the founders of ECOWAS need to look at it to ensure that the goal of regional integration is not obscured, while the court continue to project a human rights image. Thank you very much.
Thank you very much, Professor Alabi, for your very interesting and incisive comments. I'm going to turn it over to Peter Brett now for some of his comments on your presentation, and then we'll open it up for Q&A. Peter.
Yes, many thanks indeed to Professor Alabi. I think the comments show why it's important to have scholars who are specialized in both law and politics.
Thank you.
Yes. because you're raising all the important questions which are sometimes missing from one literature or the other. Notably, from my perspective as an international relations scholar, the question of enforcement, which you finish with, is absolutely central. And something else I think was very important in what you were saying is that in one sense, you are not taking a Eurocentric approach. And what I mean by that is a lot of the ways in which regional economic communities are studied begin by asking if a particular institution is following the European trajectory or not. So is it moving from a functional integration like the European coal and steel community towards supranational integration like with the European Union? And yet the question you are asking is not why did it not go the European way, but could it not do it the other way around? Could you not begin with human rights as a vector of integration and see if that delivers something more functional later? And it's an interesting question. There's no reason why not. And yet you show so many of the difficulties. So I enjoyed this a great deal. And perhaps all I want to do is ask two big questions and one small question. And then I will leave it up to you, Professor, to decide if you want to address any of those questions, but please feel free to ignore anything and deal with it later in the Q&A. So maybe begin with the small question. My small question is about what seems to be this quite important technical issue about locus standi and standing. So it appears in effect that the court has operated with quite restrictive rules about material deprivation to the litigant, which have served to reduce access in some ways. And I was just wondering, is that restrictive rule on standing required by the text of the protocol, or is this really a feature of judicial interpretation and the jurisprudence of the court? Is this perhaps the judges being strategic, or is this something they're simply required to do by the text of the protocol? That was my small question, because it seems like you're raising quite an important point there. Other than that, I have my two big questions. My first big question is, there's a large puzzle here, Rick. We have states which clearly appear to have very little political will to see this court as an integrator. And I think for all the reasons that you've laid out, why, if they wanted a regional integration court, why would they have been so slow to ratify? If they had wanted a regional integration court, why would they not have created an effective enforcement mechanism? And if they wanted a regional integration court, why would they not bring any trade disputes to the court? In fact, they seem to me to be following the pattern of all African regional economic communities, where states never bring trade or commercial disputes against each other to the court, as was apparently intended. So in those very interesting statistics you showed us, you can see it's overwhelmingly private litigants which are bringing these cases. So on the one hand, you seem to have little political will to see an integration court, which is what it was ostensibly created to be. And yet on the other hand, in 2005, apparently, you get an extremely generous human rights jurisdiction created with rules on access. And not only is it human rights cases, isn't this right? They don't even restrict the kinds of human rights which the court can adjudicate. It's the court itself which limited the kinds of human rights by adopting the African Charter as its reference point. That was the judges of the court themselves which did that. But still, it appears to be the states embracing an extremely expansive human rights jurisdiction, leading, as you say, to socioeconomic cases about the environment and so on. So how can we put these two things together? Apparently very limited political will for some very functional integration cases, and then an extremely generous, optimistic approach to the rights dimension. I was wondering if you can solve that puzzle for us.
Thank you very much. And so, oh, sorry, are you?
I have another question, but
no, please carry on. Carry on. I thought you were finished.
Yeah, sorry.
Go ahead.
I asked that in a very long-winded, discursive way. The second question is the second big one. You sometimes see scholars, I'm thinking here of Karen Alter, for example, and some others who have studied from a political science perspective, they look at the European case and they say there are reasons to be optimistic. Because if you look at the early years of the European Court of Justice, it only had very limited authority. There was states often didn't seem enthusiastic about enforcing judgments, specifically Charles de Gaulle in France. And yet they suggest that the mere fact that states appear to have accepted some supranational authority means that in the long run, they will be caught in the web. Because they haven't explicitly rejected it, they will in the long run find that their sovereign prerogatives have been lost in a series of small decisions. And the European example, like a European Court of Human Rights, it had hardly any cases in its first 30 years. And then it was other developments in the 1970s where suddenly it took off. So I don't know, what's your own view to this optimistic account where perhaps even if it seems like states are not enthusiastic now, won't they be caught in the web later on? Isn't a line of thinking? Yeah.
Thank you. And so before we move on to the Q&A, I'll give Professor Alabi an opportunity to respond to these particular points.
Yeah, thank you. You've raised quite important issues because even in setting up the ECOWAS courts, everyone was looking towards a kind of court that could function in the same way that the European court was functioning. But the environment here, the African environment was and is still not clearly as favorable to litigation, particularly on a cross-country perspective at a regional level, as we witnessed. And it appears that the judges of the court that were the initial one that were first appointed were caught in that kind of timidity. They were very cautious. In fact, the first case that came before the court, the judges were given a very strict construction of their own jurisdiction. The legal text gave them the jurisdiction, but they were also, perhaps because they are aware of the knowledge of the environment in which they were operating, they did not come out forcefully. They put a number of guiding principles as conditions that must be met before the human rights framework of the court could be assessed. And it did not take them until some 2-3 years later, when that important pronouncement in the anti-slavery case was made, that everybody seemed to wake up, that the ECOWAS court could begin to play the kind of role that is playing some 15 years later. So the judges, from their background perhaps, were not active in ascribing jurisdictions that the court did not possess. They were just trying as much as possible to work within the ambit of the letters of the law, while ensuring that they do not ascribe to themselves. Because if you go deeper into the relationship between the ECOWAS court and the national court of the member state, you discover that there is a silent war seems to be going on. For example, here in Nigeria, the law is that a treaty cannot become enforceable in Nigeria even after signing until it has been domesticated in the Nigerian law. By implication, the judgment of the ECOWAS court at a supranational level that it is operating, the Supreme Court of Nigeria has held in a particular case that that judgment cannot be immediately binding unless certain steps were taken. So the national courts of the member states were constructing limits to the power of the supranational court. In any event, we are just using the word supranational. The instrument creating the ECOWAS court does not give it a kind of supranatural authority that the CJEU, for example, has across the member state of the EU. So the more so, the court of justice of the ECOWAS cannot activate, cannot execute its own judgment. In the procedure, if you have to follow the procedure of the court, once a judgment is given, it has to be taken and enrolled in the particular court of the member state involved, and it is the framework of that national court that will be used to ensure the enforcement. So the court itself was very tactical in ensuring that it does not come in direct collision with the national court of the member state, knowing fully well that it could not go far where the national court of member states do not agree to assist the regional court in implementing its own decisions, because it does not have that opportunity. With regard to political will, I can tell you that in the 30 years, because ECOWAS court will be 30 years now, since it was first established of its existence, and 20 years of its effective operation, you cannot count 10 actions that are brought by community institutions. You cannot even find one that was brought by one member state against another for enforcement of community obligation. When disputes arise, they prefer to use the diplomatic channel. They prefer to use the good offices of the head of state. They prefer to use interpersonal relations. And apart from that, even instead of submitting dispute, they take unilateral decisions. For example, Nigeria had been warning Benin Republic being used as avenue for dumping of unwanted foreign goods in Nigeria because of the porosity of the border. In normal climb by the ECOWAS rules and regulations, Nigeria ought to have approached the ECOWAS court to stop Benin from allowing its territory to be used for nefarious activities against Nigeria. Nigeria did not go to the court. What did Nigeria do? It just closed its border unilaterally. That is West Africa for you. Such a thing will not happen in Europe, because there is a place you can go to enforce that. Even the free movement thing that we are talking about, you find each member state manning its own border. In the supranational system, there ought to be a set of enforcement officers who are responsible and reporting directly to the supranational authority. That is not existing in West Africa. Here in West Africa, decisions of the supranational authority are expected to be implemented in good faith by the member state. Member states themselves who are violators of some of these principles. So the political will is not strong enough, and the member states hardly submit trade disputes to the court. The question you are asking a kind of dilemma. Why would they then suddenly wake up to begin to appreciate the human rights framework? Don't forget, the emergence was a consequence of the global wave the global wave of the 1990s that tend to propel development across the globe after the collapse of communist internationalism, in terms of openness, in terms of perestroika, in terms of the need to be seen, with pressure from the West too, who are asking for, who are using indices of promotion of human rights, openness, democracy, and the rest as a yardstick for more aid, as a yardstick for financial assistance here and there. So the ECOWAS leader was sort of stampeded into setting up a court. They did not have the kind of vision that the court could be performing the kind of role that it is presently performing. So it's a dilemma. They wanted to be seen to be opening up the space in a line that is supported by the global wave. But deep down, they lack the will to want to subject themselves to the implication of having a supranational authority that could put them in check. So while they did it, the enthusiasm wasn't very much assertive as one would have loved it to be. So the dilemma persists and it continues. Secondly, the increase in the human rights litigation ability of the court is not a function of a change of attitude on the part of the member state of the ECOWAS. Don't forget, the human rights litigation are activated by individuals and not by the member state. So the timidity of the member state continue, and most of the time, human rights litigations are taken against those member states. So it has not affected them in one way or the other because they go to the court to defend cases of violations. And to further strengthen my point that the political will is still lacking, even when such judgments are given, they hardly allow it to be enforced. So it's neither here nor there. Thank you.
Thank you very much. So we have plenty of time for Q&A right now, I think. If you want to ask a question, please raise your hand within Zoom, or just turn your camera on, raise your hand. And in fact, I'd invite everybody to turn their cameras on now if they wish, or you can put a question in the chat. I see Pantian has put a question in the chat, but Pantian, would you like to put it directly to Professor Alabi?
Yeah, I can do that, Kurt. Thank you very much. I just thought I would run down the clock by typing my questions. Professor Alabi, thank you so much. I thought that was really brilliant. That's fascinating. I'm probably biased because I'm an international commercial lawyer, so maybe I have a bias.
Okay, that's your area.
Probably just listen a bit more because I'm into conflict of laws, and I've written actually on this book chapter and paper on the ECOWAS Court and the SADC Tribunal. So I thought it was really fascinating. And Peter, I think, I don't know if you're a lawyer, but you spoke, everything you said was very on point concerning the law. So if you're not, then you've missed your calling. Right. Okay. So can I just say that I've argued in the past, there's a lot riding on the ECOWAS court. That's what I think. I think the court is really congested and saddled with a lot of different elements at the moment. And what I've said in the box, I said litigants feel that they need to characterize their claims in a human rights manner. That's what I've seen. If you look at some of the conflict of laws cases, if you look at Chude and Mba, for example, that tried to enforce human rights matter as a compensation matter. That's a fairly recent case. And that couldn't be enforced, of course. It's a Ghanaian judgment. Nigeria had obtained a judgment in Ghana and tried to enforce it, and it just wouldn't work because Ghana had not ratified the protocol in that regard. And what struck me as an international commercial lawyer is because compensation can be, for example, purely financial or from a human rights aspect. So, for example, if you have a human rights problem, the court can actually give an award and say you should give money as compensation. So that to that extent, it's a financial matter. We then find that yes. So you then find that if you look at other cases, and I looked at a number of them, then it seemed that litigants thought the savvy way to go about getting the attention of the court was to find a way of looking for human rights things, whether they were relevant or not.
Thank you.
Sort of just to get the attention of the court. And I'm thinking, if you're doing that, I think it's not a systematic way of developing the jurisprudence of the court. Because it's not a genuine mode of evolving the jurisprudence of the court. So that's one position I had. So I wasn't, perhaps that's what you also have in mind. But
yeah.
my question also is, you see, when you talk about the original aims of the court and regional integration, and I think that's where Peter made a really striking comment when he said, are they mutually exclusive? I think what he was saying, if I remember, was something like, is it not possible that human rights can also facilitate regional integration? Does it have to be one or the other? And my position on that really leads to my question, namely, if the politics which comes with human rights is partly what has become the burden of the court. That happens in ECOWAS, that happens in SADC. And I've said this to everybody that has discussed this issue with me. I said, that's fine. The SADC tribunal, they enforce a fabulous judgment against Zimbabwe. What then happened? The court collapsed. The tribunal is no more. It's suspended. So it's not the question of, so there's a dichotomy between reality in terms of what the courts can do, and if avoiding issues that are highly politically charged. As we speak, I'm not aware that the SADC tribunal is back in force, but you can then point to an empty shell and say, yeah, but we enforce it's like winning the battle and losing the war. So what's the point? So I think, and that leads to my question. My question then is, I've been a bit long-winded about this, but my question then is, if you look at all the things I've said, you propose an expansion of the ECOWAS court's approach, or do you propose a restriction? In other words, would you then say the solution is to have a different court or sub-court which would attend to different claims, or would you say this should be expanded rather? And then is the issue also with changing the litigants' strategies? And I say this because you made a fascinating point about the fact that a lot of the human rights, in fact, almost all of the human rights claims are against governments. And the reason governments don't want to enforce them is that they are already controversial. So for example, if you take a case against the Secret Service in Nigeria, they're coming back to the government to tell them they should enforce it against themselves. They are not sophisticated enough. They are not genuine enough to accept that the effect of a ratification of a treaty means that you cede some of your sovereignty. And I think that's a realistic issue. So let me stop there. I could probably speak all day because it's something I research on, but I just think it's something which I find very fascinating. And thank you so much, you and Peter. I thought that's a really great job. Thank you.
Thank you, Pantin. Professor Alabi.
Thank you. I really appreciate Pantin for the area that you have just helped us throw light on. In fact, the example of SADC is what we said we are looking at when the judges of the court are trying to be cautious in what they do, because in Africa here, we have to be mindful of the difference between what a court of law can say and what the court of law can in reality do. As it is today, I won't recommend that we set up a human rights court specially, because that is tended to create more problem than solve. But the interpretative powers of the court could be such that, and that is the point I was making, that they will allow people, litigants, to succeed even when they do not lump their claim with human rights issues. The only reason why many persons bring about human rights as a claim on their application whenever they file it before the court is because of the provision of Article 9 of the Supplementary Protocol that allow human rights issues to be brought. So once you raise the human rights, the court cannot dismiss your case in limine. They must hear you. Even if at the end of the hearing, they now discover that you only put the human rights claim as an opportunity to come to the court. But if the judges of the court will remove the restriction that are often placed on individuals in terms of sufficiency of their interest on regional integration matter, on economic dispute, on trade dispute, on dispute that involve holding the community institutions, and the community officials accountable for their actions, then the less, because litigants will react, lawyers like you and I will react in framing our claims to what our perception of the vision of the court is. If we know that the court is unlikely to listen to our client if human rights issues are not, we'll find one way or the other to put in there. In Henry Oku, the man was fighting the ECOWAS as an employee. There was no human rights issues involved. But for them to be able to get access, they put human rights claim. But the good thing that was that at the end of the day, the court itself was able to see that there was no way the human rights of Henry was violated. But time has been wasted filing the case. Time has been wasted going through the trial, because everybody feels that the easiest way to approach the court is to put. So if the court, in constructing its own own legal order for the West African sub-region, should begin to place less emphasis on sufficiency, because there's no way you can raise the issue of sufficiency of interest in regional integration matter without invariably asking people to start whipping up sentiment as to whether such actions has violated their rights. If the court would change its judicial approach such that litigants will no longer see putting human rights issues in the front as a shortcut to gaining the attention of the court. In the alternative, the court can now begin to sit in divisions, create a human rights division of the court and a trade dispute division of the court to promote regional integration. In that case, that will involve more challenges again, because new set of judges will have to be appointed, the framework will have to change, and going by the way the court is operating for now, the member states are even complaining of paucity of funds. So, but if we really want the court to begin to pay attention to the main objective of promoting regional integration, we have to find a way of giving opportunity for individuals and corporate individuals to deepen their litigative ability in those particular respects, rather than just leaving it. Yes, I agree with Peter that probably the human rights litigation may be a springboard for what will happen to the ECOWAS in future. But the way it is now, the court is virtually almost forgetting that aspect of its jurisdiction that is intended for the sole purpose of ensuring integration in the West African sub-region. That is one. But the matter is not to be solved by the court alone. In the paper, I said the judicial framework of the court, like that of any judiciary, is not self-activating. The judges of the court will not manufacture cases. So if the legal instrument says cases to be brought by member states and community institutions, and they are not bringing them, there is a little to the extent to which the court can. But if in the very few cases that come before the court, the citizens see a ray of hope for their non-human right litigation to succeed in the ECOWAS court, we may begin to see a drift towards the court in preference to the domestic court of member states. But if the court continues to put the issue of sufficiency of interest at the front, litigants will be discouraged. And to that extent, everybody will begin to rush to that area which they are more assured of success in the court, which is the area of allegations of human rights. And my position has been that as long as that heavy workload of human rights persists on the court, the tendency exists for infringement of community texts among members to continue because nobody is paying attention to that. It will exist for the community, its institutions and officials to continue to act when no one is challenging the legality of their action. It will continue when members, states, domestic court constitute major impediment to the implementation of the decisions of the ECOWAS court. So if we are so much obsessed with human rights, which I don't deny can contribute to the growth of this other aspect at a later date, the tendency may be that in the next few years to come, we may virtually forget about the fact that the ECOWAS court is a regional integration court. Thank you.
Thank you. While we're waiting for other questions, I just want to sort of follow up on a couple of points that have been made here. Given the experience to date with the court, and especially the problems with enforcement, et cetera, and relating to some of the points that Pontian made about the problem that we've seen elsewhere with regional courts trying to actually do something, and then that leading to it all falling apart. And the problem that you pointed out that the ECOWAS court is sort of not really focused on the issue of integration per se, to the extent that perhaps it should have. What do you think this says about the broader project of integration, both regionally and perhaps continentally? Pontian referred to the question of sovereignty, et cetera. So I'm wondering whether you think that this has any broader implications, the experience to date.
Yeah. What we are witnessing in the ECOWAS is a fallout of what happens across the continent of Africa. The free trade agreement for a continental framework for the whole of Africa had been signed for quite some time now. We are still trying to fine-tune and look at it and see how best we can operate. But then, as we work towards ensuring continental free trade agreement, towards facilitating cooperation and collaboration, at every stage of it, I ask myself, are we really ready for this? Because as we are taking 2 steps forward, sometimes we take 3 steps backward. There are motions, there are no movement. We seem to be interested in projecting some of this image without necessarily taken appropriate steps to back them up, and everything still border on the fact that we are really not ready to let go our quote unquote hard and sovereignty. The issue of each country wanting to have the final say within its own territory is a major inhibiting factor in implementation of multilateral agreements in this part of the world, including agreement that deal with free trade, including agreement that deal with common market. If we are opportune to go wider than the court and set up the stages towards the common market that the ECOWAS leaders set for themselves as far back as 1975, when the ECOWAS was set up as a regional economic community, we see that we have not really go past what we have, because as at that time, they even put a timeline. By so year, we are going to achieve this. By so year, we are going to achieve this. Yet, the one that we are able to, it has come to a stage in the past that I first satisfied in my mind that, okay, that we have achieved the free movement within the West African sub-region. But suddenly, some countries just decided to violate the protocol. And in the absence of effective sanctions against those countries, other countries are doing it. And today, you want to ask yourself, of course, I can travel to Abidjan the way I like, but it's not the same way that I will pick my car on the street of Paris and drive far, Strasbourg, drive everywhere, and nobody will ask me a question. I will still have to stop at each and every border to do as if I'm a foreign citizen, even though I carry an ECOWAS passport. But nonetheless, when I go there, they will still treat me as Nigerians, not as an ECOWAS citizen. So the issue of sovereignty is very deep in our mind. We are not really at a point that we can begin to subscribe to the level of supranational submission that can assist in deepening the process of regional integration. Because for regional integration to succeed, we must be able to create a level of authority that will be able to enforce certain decisions against member states, whether that member state like it or not. As of today, the member states are the one to determine which aspect of their sovereign power they want to subscribe. Yes, I subscribe to the theoretical underpinnings of the fact that multilateral agreements are made by states. But we should be honest with ourselves that we have a right to either go into it or not. But if we decide among ourselves that we want to go into it, then we should be willing to part with that aspect of it. And very recently, the ECOWAS Court made that point forcefully, that since members have decided to go into a treaty, in fact, the court actually used the word supranational, that once the member states have decided to sign the treaty and form, they should be prepared to do away with some of their sovereign powers in areas where they have commonly agreed that such power be suited declaratively. Yes, the press captured on that. Everybody was happy. But what is the outcome of the compensation awarded by the court? Up to today, it has not been paid. Up to today, nothing has happened. But at least we are relieved by the fact that there is one, quote unquote, supranational authority there that can condemn. And if the goal for now is to have this sense of satisfaction that at least some of these fronts to decency are being brought to the limelight, to the court. That is it. We should be happy. But if the ultimate goal is to see that these proclamations by the court are really effective in terms of their impact on ordinary day-to-day life of the citizens in each of the 16 member states, then we haven't got anywhere. So the goal is to try to put pressure on the leadership, I mean the political leaders now, to appreciate more the impact of what we can do together rather than seeking to go it alone. Africa is not devoid of grandiose ideas of unity. Don't forget the era of Pan-Africanism, the era of Kwame Nkrumah that is looking for a United States of Africa, the era of the African unity, even from where we moved to African Union. But to what extent have these translated? Ordinarily, between Burundi and Rwanda, there are border skirmishes. And if our vision is continental unity, should such small clashes become a major factor for disunity across the continent? No. The truth is that while we have grandiose ideas of unity, grandiose idea of free trade, grandiose idea of supranationalism, what we are seeing on ground in terms of their impact on what operates within national borders does not suggest that Africa can be there as quickly as we are thinking. Thank you.
Thank you very much. I think we have time for another question or two. If anybody would either like to raise their hand in Zoom or turn on your camera and raise your hand, I will be happy to entertain your questions.
Please permit me to acknowledge the presence of Professor M.J. Balogun. I'm just seeing him now. You're welcome, sir. Thank you so much.
Thank you. If there are no questions, I think it then falls on me to thank Professor Alabi for his very insightful comments, and also to thank Dr. Brett for his comments, and to thank all of you for participating, and then to turn it over to Dele. I think he wants to make a couple of announcements.
Thank you so much, Professor Kotmings, for being there with us. Thank you so much. I don't know if Professor M.J. Balogun wants to say one or two things. He's just joining us now before we move to a short presentation about Dundee African Research Network. And then if we don't have any questions, then we close the presentation. Okay, if there is no comment, okay.
Dr. Ario Bakar is also coming on board.
So, Dele, you seem to have frozen.
Yeah,
Can you hear us?
No, I think Dele has frozen.
Yes.
Kurt, just let me know if you need me to step in on the Dundee Africa Research Network front to run down the clock while Dele comes back. I can speak to that since I'm one of the conveners. But
that probably makes sense, and hopefully Dele will reappear.
Yeah.
Go ahead, Pantian.
Yeah, I'll just say a word or two, and hopefully we'll be able to sort of run down the clock and see if he comes back. So, Court Mills, I think it's a once again, I thank everybody for, and it's not a final vote of thanks or anything. It's just me trying to fill in the gap. I think it's been a very fascinating discussion. Once again, it's I'm really excited. I sort of just feel this should just go on and on and on. I'll just say a word or two about the Africa Research Network. Coincidentally, Kurt here has been a founding advisor to Dundee Africa Research Network. So, of course, the pandemic hasn't quite helped. I've not seen him in quite a while. I think the last time I saw him was before the pandemic in his office in Dundee. So the pandemic hasn't been too kind. But Dundee Africa Research Network was formed in June 2015. And since then, we've had so many events that have attracted speakers from all over the world, from South Africa, from Asia, from Latin America, North America, and all of those places. And of course, our partnerships, as you can see, for example, with BISA, our last event was with the University of New South Wales. So we've had very successful events. Our long-term aim is it's channeled towards that African International Research Center focus. And a strong pivot of what we do is interdisciplinary work. As we have seen here, this is a classic example of what we do, having law, having politics, delays and international relations and politics, arm and law. We've got folks in economics. Kurt himself is very much international relations expert. Peter, I was confused today if he was a lawyer or not, but that gives you an idea. And that gives you an idea of the synergy we produce here, and we'll come together. So we hope really that there will be a lot more of these partnerships in this regard. I didn't know, for example, that my area of research was so closely overlapped with that of Professor Adil Alabi. So and these things have brought our inner aspirations to the fore. So I like to sort of hope that we drive that even further, and that everything continues to go towards that direction. For the other participants who wanted to say anything, I think I'll have to sort of ping that back to Kurt Mills, because if Dele is not coming back, then I think on behalf of Dundee Africa Research Network, I'd like to very much say how much we've enjoyed this partnership with BISA, and how much Kurt has been a very, very supportive advisor to Dundee Africa Research Network. And of course, Professor Adil Alabi himself, who has undertaken a very, very masterful discussion on this in this matter. So thank you so much. So I would just assume that Dele won't probably be able to come back before we close. So can I ping this back to Kurt, and then it's for him as the chair to decide when and how this will be drawn to a close. But thank you so much.
Thank you, Pantian. And just to say, I've been very impressed with some of the events and other things that Darren has done over the time that I've been in Dundee over the past 4 years. And so I'm very happy to see that they are continuing and putting together wonderful events like this. It looks like Dele is not going to be able to rejoin us, unfortunately. Some of the downfalls of Zoom, I guess. So I think it probably then just is left to me to once again thank our speakers, thank all of the participants for your questions, and to close the event until next time. Thank you all very much.
Thank you.
Thank you so much. Thanks, everybody. Have a good time.
Thanks, everyone. Thank you, Professor, and thank you.
Thank you.